City Talks with Reuben Abati.
Hello, good afternoon, and welcome to another exciting edition of your number one talk show, City Talks with Reuben Abati, on your number one lifestyle station, City 1051 FM. On this show, we talk about stories of political and human interest that affect us as citizens of Nigeria and that affect us also as members of a global human community. Today, we will be discussing, among other subjects, the removal of the Ebonyi State Governor David Umahi and his deputy, Dr. Kelechi Igwe, and 16 others from office, following their defection from the People's Democratic Party to the APC. We will also be looking at the leadership crisis rocking the All Progressives Congress, APC, and then the Senate's rejection of the request by the President for the amendment of Section 84, subsection 12, the clause disenfranchising, so the presidency claims, persons holding political office from taking part in the electoral process, except they resigned their appointments long before the primaries, as that particular section of the law stipulates. We'll also be looking about the protest by Nigerian women about what they consider to be the misogyny, the act of discrimination, a declaration of war against Nigerian women with regard to the 5 gender bills that were part of the constitutional amendment process, which were more or less rejected by members of the National Assembly. And to discuss these issues, it's a privilege to introduce a seasoned Nigerian human rights lawyer and activist who is our guest today, Inibehe Effiong. Inibehe Effiong is a radical activist, a social crusader, a writer, a columnist, and a critic. He has written extensively on the various problems besetting Nigeria. His articles have been published in most of the major newspapers and online news mediums in Nigeria. He graduated with a Bachelor of Law degree from the University of Akwa Ibom State in 2014. While in the university, he was actively involved in students' unionism. He was a member of his faculty students' parliament when he drafted a new constitution for the Law Students Association. If you want to be part of this conversation, you can call us on 0700 1051 1051. You can also leave comments on our WhatsApp number 090-991-64403 and on our social media accounts at City 1051 on Zoom, Instagram, and Facebook. First on the list is the Electoral Act 2022, the Electoral Act Amendment Bill 2010, and the controversy that generated about whether or not the president should have signed by February 22. But the president still eventually signed, and INEC has already come up with a schedule of election, with a notice of election. But the contentious part of it is Section 84, subsection 12, which the president had originally said would amount to a violation of the rights of political office holders under sections 40 and 42 of the Constitution. And the other day, when the matter was tabled before the Senate of the Federal Republic, the Senate voted overwhelmingly against the request of the president. I would just like to draw your attention to one thing about the women. Yes, the women are alleging discrimination. They are alleging misogyny. There were about 5 gender bills before the National Assembly in the course of the consideration of 68 clauses, in the constitutional amendment process. And one clause has to do with citizenship, which simply says, as proposed by Honorable Nkuruka Onyeji-Ocha, representing Isukwato Federal Constituency, to say that in terms of citizenship, a Nigerian woman that is married to a foreigner, that the spouse is entitled to citizenship of Nigeria, as is done with regard to women, for example. And 2, indigenship, that if a Nigerian woman, has lived in a particular state with her husband for about 5 years, then she's entitled to run for office in that particular state, to hold positions, whether appointive or political, rather than the present situation whereby women are told, oh, you are not from our state, you are just a wife here. If you want to hold a position, then go back to your original state where you were born. Now, the women are saying this is discriminatory per se, and it's against, gender equality principles and also Section 42 of the Constitution. The proposer was also asking for affirmative action for women in political appointive positions, and that was shot down in the Senate. The Senate, the House of Reps reviewed it to 20%. There was also a request for appointive positions, affirmative action, again 35%, for women representation in political parties. That was also shut down. The proposal was also that, look, 111 extra seats should be created for women in the National Assembly, 37 in the Senate, 74 in the House of Representatives. That also was shut down. The other request was that, look, in the state houses of assembly, one position at least should be reserved for Nigerian women in state houses of assembly. That again was shut down. And, on March 2, Nigerian women protested. On the occasion of International Women's Day, there was a protest about the need to break constitutional bias. And, what the Nigerian women are asking for is nothing unusual. In other parts of Africa, in other parts of the world, in Zambia, in Kenya, in South Africa, to cite one notable example, there is affirmative action for women. But here in Nigeria, there is this constructive discrimination. The latest development is that the House of Reps has now said it will take another look at least 3 of those issues when it goes through the second round of constitution amendment processes in 2 months' time. And those 3 issues will be citizenship, internship, indigenship, and affirmative action for women. That's the situation with regard to that. I don't want to be the one to do the talking. We'll take more calls while we're waiting for our guest, Inebe Effiong, to be able to establish connection with us in the studio. Inebe Effiong, any success?
Good afternoon, Dr. Abati.
Oh,
good.
At last you can hear me. Okay.
Yes, clearly.
Very good. Okay, I started with the amendment of the Electoral Act 2010, now Electoral Act 2022, and the President's position on Section 84, subsection 12, which continues to generate a lot of interest. If we could start with that, I would like to have your take.
On the issue of proportional representation for women, it is obvious that the current crop of legislators that we have in the National Assembly, they are neither progressive-minded nor in tune with global realities. Their votes and position on this matter show that they belong to the past. While civilized countries across the globe are striving to ensure proportional representation for women, the Nigerian parliament is not even ready to allow a debate on the point. They could not even allow the matter to get to a stage where the houses of assemblies could vote. They just shut it down without robust debate, without robust engagement. And what that shows you is that we have a political class, both PDP and APC, who are the main parties in the National Assembly, taking a position that does not address the yearnings and aspirations of the Nigerian people. I totally support the entrenchment of proportional representation for women in political positions, both appointive and elective. A country like Rwanda has almost majority of its representatives being women. In Nigeria today, you can count with your fingers the number of women that we have in the National Assembly and the various state houses of assemblies. You can also count with your fingers the number of ministers that are women and commissioners across states that are women. So women have been deliberately and diabolically sidelined from the political system. And I believe that this is an issue that has to be addressed constitutionally. Obviously, if the political parties were responsible, there wouldn't be need in the first place to have a constitutional argument or debate on the issue, because political parties could have addressed it at their level by making it compulsory that both at the party level and at the level of leadership, anybody who is elected on the platform of the party will implement the manifesto of the party, which should incorporate proportional representation for women. But I've made the point that the so-called two major parties, they belong to the past, and that is why it is a bit difficult for them to understand why women should be proportionally represented. So until there is a law, a constitutional amendment to address this, Nigerian women will continue to lag behind in the political process. So I express my total aversion for the vote of the National Assembly on the bills that sought to integrate women fully in the leadership of the country. But the other point I want to make is that beyond legislation, there are systemic issues that we have to address. We have the infamous, or the now much talked about not too young to run bill that was later passed and made part of our constitution, which essentially reduced the qualifying age for aspiration for elective office and appointments for appointing offices. Now, despite that, the question is, since the constitution was amended to downgrade the age requirement, how many young persons have succeeded in winning elections? How many young persons have been appointed ministers on account of that amendment? How many 30-year-olds do we have in the National Assembly? Do we have as commissioners? Do we have in the House of Representatives? How many 35-year-olds do we have as governor? So you see that beyond the hard letters of the law, we have a very terrible political system in this country where the class of 66 are still determining the fate of the country. And that is why you would see people who should be attending to their grandchildren and waiting on God to call them, still insisting that they want to rule the country. But because they simply cannot understand, why the younger generation should take charge of the leadership of the country. And for me, this is very tragic, but it is not just a question of age. It is also about the quality of the age. So while some of us are in favor of youth inclusion in politics, we are more attuned to effective and quality youth participation. But that is not to make an excuse for those who have brought the country to its knees. And I believe that there has to be a generational shift. So whether we have a debate on inclusion of women in politics or not, the reality is that until the electoral system is fundamentally altered, until the political system is systematically reformed, even if you have it enshrined in the Constitution, except it is made mandatory from the stage of nomination. If you give room for discretion, it's not going to happen, because that is the mistake with the not too young to run agitation. There was no proper entrenchment of that principle in the Constitution. If it was made a constitutional requirement that every political party shall reserve a certain percentage of its aspirants and positions to persons below certain age, it would have been sensible. But when you just say if you are less than so and so age, you are eligible to contest, whereas the political power is still in the hands of those who are tired but have refused to retire. So, Dr. Abati, that is my sentiment on the matter. And regarding the position of the President on Section 84 sub 12 of the Constitution, of the Electoral Act 2022, I do agree with the President in principle that that section is unconstitutional. Because if you look at the letters of that section, it is a bit problematic. The first problem I have with that section 84 sub 12 is that it says that political appointees cannot participate either as aspirants or as delegates in the convention or congress of parties. So why are they limiting it to political appointees? And the phrase is also not defined. Who is a political appointee? I have had that question before. it is not defined. The National Assembly left a lacuna by not clearly and expressly defining who a political appointee is. So supposing that the reference to political appointee here are persons who are appointed into elective positions. But you also have political appointees in the legislature. So because we have to ask what the intent of that amendment is. If it is to ensure that those who occupy political positions do not use the paraphernalia of their office, the incumbency of their office, to substantially alter the electoral process in their favor, it will be more sensible to start with those who are elected. Governors, president, vice president, and so on. Why are the lawmakers excluding themselves? See, for me, it doesn't make sense. It shows that the amendment is not in good faith. If the true intent is to ensure that there's a level playing field for every person in the primaries, then members of parliament too should be affected by that amendment. But when you just limit it to political appointees and say you cannot run for office while you are still holding office of a minister or commissioner, it is clearly unconstitutional, because the qualifications for occupying elective offices in Nigeria have been expressly provided for under the Constitution. And the relevance as far as the issue of occupying an office is concerned have also been provided for, which is that you have to resign not later than 30 days to the time of the election. So the National Assembly cannot add or subtract to the provisions of the Constitution regarding that. That is why I do agree with President Buhari that section is unconstitutional. But that is on law. At a political level, I also feel the president is being quite hypocritical on the issue, because there are other contentious provisions in the new Electoral Act. Now, the president, who claims to be conservative, who claims to be a man that is very, to have a sense of fiscal responsibility, even though that has been proven to be false in the last 6 years. How come that we now have 5 billion set as the threshold for presidential elections, raised from 1 billion? It is an embarrassment. You now have 1 billion set at the threshold for gubernatorial position instead of 200 million that was in the repeal Electoral Act of 2010.
The Electoral Act 2022, and now the INEC coming forward to give the notice of election and all of that. How much of a step forward do you consider the fact that we now have a new electoral framework? Because there are some other commentators who have said, well, there are some positive sides to that Electoral Act. And commentators have identified at least 10 aspects that would seem to be a major advancement in terms of the electoral framework in Nigeria. What do you think? Hello? Hello, did you hear me? Okay. Maybe while we're trying to re-establish connection with our guests, we'll take more calls from the public on the subjects that we have outlined for conversation. The question I had asked in Ibehe about some positive sides of the Electoral 2022 and how that amounts to an advancement of the electoral framework will include, for example, the right of persons living with disabilities to be able to vote, and that's under Section 54 of the new law. And that will also include the early commencement of campaigns. That's under Section 94 of the new law. And that will also include the fact that funds will be released early to INEC, so that INEC will be able to function far more effectively. And that's Section 3, subsection 3 of the law. Now, there is electronic transmission of results, now recognized under the law, Section 50. There's also electronic accreditation of voters under Section 47. Now, BVAS, smart card reader, all of these will now be acceptable. But it looks like someone is on the line. Please go ahead. Your name, your location. Okay, we lost that. And then the new law is also insisting on the political neutrality of INEC officials. And it's also talking about, in Section 51, about how, overvoting has been redefined. And under Section 65, where there is any indication that election results were declared under duress, such results could be cancelled. This is what some civil society organizations have argued constitutes part of the positive sides of the new law. But I would have wanted Inibe, if we can re-establish contact with him, to talk about some other issues, particularly the ruling by the Court of Justice Nyangekwo of the Federal High Court on the defection of the governor of Ebonyi State, David Umahi, his deputy, Dr. Kelechi Igwe, and 16 members of the Ebonyi State House of Assembly to the All Progressives Congress, the ruling party from the PDP. Hello, Inibe. Can you hear me now? Hello, Inibe. Can you hear me?
Yes, Doctor, I can hear you.
Okay, please go ahead.
Essentially, I don't know whether you want me to start with the Ebonyi matter.
Yes, maybe we should go straight to the Ebonyi.
The certified true copy of the judgment, and I read it from start to end, and I find the judgment a bit interesting. There are aspects of the judgment that I agree with. There are aspects that I do not agree with. Now, primarily, it appears that the judgment of the court was predicated on the fact that, by the reasoning of the learned judge, the vote cast in the 2019 gubernatorial election in Ebonyi belonged to the People's Democratic Party, and that the said vote was not transferable, and that David Umahi and his deputy, having defected from the PDP, the party on which platform they were elected, the party that owns the vote, has held and reasoned on the basis of being defective. So that essentially is the jurisprudential basis for the judgment. Now, do I agree with the reasoning of the court? It is not a very simple matter, so I'll try to summarize. Now, regarding the question of ownership of vote, so much has been said about Section 221 of the Constitution, which says that no association other than a political party shall canvass for votes for candidates at election. And of course, reference has also been made to the case of Amechi and INEC, which was determined by the Supreme Court in 2008, and of course the case of James Abiodun Faleke that arose from the state gubernatorial election when the late Abubakar Odu passed on. These are cases that I am familiar with. So it is on that basis that the court held that the vote belongs to the candidate. Now, if that was the end of the matter, if that is all that the Constitution says, if those are the only relevant legal issues, then maybe there would have been sufficient legal basis for the judgment to survive appellate scrutiny. But when you look at it in a broader sense, which is how the Constitution should actually be examined when its sections or provisions are to be interpreted, you have to look at it as a whole. You will find it very difficult to agree with the judge. First and foremost, the Constitution is clear. In fact, let's even start on the issue of who owns it. In fact, let's even go to the issue. Now, if, as the learned judge directed, because I have read the relief sought, where the PDP asked that it should be given and the court should make an order for it to nominate candidates to replace the governor of Ebonyi State, Umahi, and his deputy, or in the alternative that INEC should conduct fresh election. I don't think those are orders that are grantable in law, because when PDP is now nominating persons to replace Umahi, as the national chairman of PDP actually announced, who are these persons? What qualifies these persons to be governor and deputy governor? In terms of age, in terms of educational attainment, and other requirements under the Constitution, and who is going to determine whether they have met those requirements or not? Because for a party, even if the argument is that the vote belongs to the party cannot earn votes except it has validly nominated candidates in an election. And that nomination can only be done at the primary, whether it is under the Repeal Electoral Act of 2010 or under the Electoral Act of 2022. Candidates of political parties must emerge through primaries. So when you now have a judgment of court saying PDP can nominate replacements of Umahi, supposing, let us have an hypothetical question, that PDP nominates somebody who is 18 years and says, this is who we want to replace Umahi. Will INEC be within its power to say they are not going to accept that person? Supposing the issue of appeal, supposing APC has not appealed and Umahi has not appealed, supposing there is no motion for stay and the judgment is to be given effect to, and supposing INEC says, well, we don't have the resources for fresh election, we are awaiting your nomination. INEC cannot disqualify a candidate. It's only a court, it's only a tribunal can do that. So who will now determine the eligibility? Is it the party? Is it the party? Because for you to participate in an election, you have to fill the relevant forms. You must depose to an affidavit to say that the information you have even supplied is correct. This prerequisite cannot be met at this point. And there is no primary for these people to emerge. So that becomes problematic. Again, the other issue of whether or not really, even if we agree that the votes belong to the party, what is the effect of defection? The Constitution at the court itself even found, the judge in his judgment said that there is a constitutional lacuna. The judge says so. I read the judgment. And the judge said there is a lacuna, but that even though there is a lacuna, that the APC cannot take advantage of that lacuna because it will amount to reaping where they did not sow. Well, at the level of judicial activism, that is agreeable. At the level of morality, that is agreeable. But when you look at it from strict law, strict principle of law, the matter cannot be agreed, that position cannot be agreed to. So simply because while in the case of the legislature, and the judge also made that point in his judgment by referencing section 68, subsection 1, paragraph G, section 109, subsection 1, paragraph G, which states expressly that where a person who was elected into the National Assembly or the House of Assembly respectively becomes a member of a political party other than the party on which he was elected, he shall lose his seat. The judge cited that provision. But there is no similar provision for members of the executive. No similar provision. The Constitution does not say what should happen where a person that is elected as president, as vice president, as governor or deputy governor leaves the party on which he was elected and defects to another. The Constitution does not say, and that was why in 2007, when the then vice president of Nigeria, Atiku Abubakar, defected from the PDP to the Defunct Action Congress, and Obasanjo had his office, President Obasanjo then had his office through the AGF declared he was elected, he had impliedly resigned. Now, Dr. Abati, the other interesting part of this judgment is that in the judgment of Justice Yaeko, the issue of implied resignation was also canvassed by the PDP. PDP said that he had resigned by implication they had resigned from their offices as governor and deputy governor, having defected. You cannot have that kind of argument after the Supreme Court has resolved the issue, that there is no express provision that says that the vice president could lose his position on account of defection. So why was that principle in Atiku's case not addressed? I have read the judgment, and I have pointed it out some minutes ago to lawyers in the platform, that that issue was not addressed in the judgment. The learned judge did not address the principle laid down in the case of Atiku Abubakar, in the case of AGF and Atiku Abubakar, even though that case was cited to the court in the judgment. But I have not seen anywhere in that judgment where a distinction was drawn between the pronouncement of the Apex Court in Atiku's case and the instant case. I understand some rulings were delivered on the preliminary objections that were filed. I'm not certain whether that point was addressed in those rulings because the copies of those rulings have not been available. But regarding the judgment itself, because I expect that to be a substantive issue, that shouldn't just be a matter for preliminary objection. That point was not addressed by the judge. That is why I am saying that until a lawyer convinces me that there is a distinction between the principle the case of Atiku Abubakar, AGF and Atiku Abubakar, and Umahi'S case, the judgment cannot survive, the judgment cannot stand. Because no matter how you look at it, while that lacuna still exists, while it is not something that should be encouraged, the Constitution has not made defection by members of the executive punishable. It does not.
Well,
and you also go further and you look at Section 180 of the Constitution on tenure of office of governor and of course deputy governor by implication. How a governor may cease to hold office when he can vacate office. Defection is not made one of those conditions. It is by reason of death, by reason of resignation, by reason of removal in accordance with the Constitution, which should be impeachment, or removal on grounds of permanent incapacitation. None of that has taken place. So what is the conditional basis for now saying that the governor should be removed because he has defected? You cannot simply say that, oh, because the votes belong.
Well, the governor and the other affected parties.
Oversimplification of a very serious issue.
The governor and the other affected parties have already gone on appeal, and they've said that very clearly. But there was also an issue about immunity, Section 308, raised by Michael Zekome SAN, in which he was saying more or less that what is even the basis.
Dr. Abati, I can't really get you. I'm not sure if you could hear me.
I can hear you. Can you hear me? Hello? Hello? Can you hear me? Oh, what a day. Okay, well, I'm sure our listeners had our guest in ABF very clearly. If you have any contribution to make on the issue of, Ebonyi State and the ruling of the Court of Justice Equal, please feel free to call in. ABF has already looked at various sides of the matter. I was just going to ask him whether indeed Section 308 applies in this particular matter, as some senior advocates have tried to point out that there was no basis for the suit in the first place. Do we have any caller on the line? Okay, while we're waiting to re-establish connection with Inibe Effiong, the other thing that we'd like to talk about is what is going on in the All Progressives Congress. There's been an issue in that political party over who is the substantive chairman at the moment of that caretaker committee in that party, and whether indeed or not Malame Malabune is still in charge. Hello, Inibe Effiong. Looks like you are back with us.
Yes, please.
Okay, I wanted you to comment on the crisis. Well, APC members will say there is no crisis in their party, but what looks like a crisis in that party over the leadership of the caretaker committee and the anxiety about whether or not the convention of the party will still hold on March 26, in the light of a letter from INEC that has now been made public.
It is a bit controversial because, in the first place, the role of INEC in regulating political parties in recent times has been a bit problematic. Now, the crisis in the APC, because clearly there is crisis. If they say there is no crisis, they are just living in self-denial. They are living in denial. There's crisis in the party. The APC as that today cannot be said to have a properly constituted organs, particularly the National Working Committee. APC does not have a functional organ at the moment to spearhead the day-to-day activities of the party. They have now come up with this abracadabra that they call a caretaker committee, or whatever strange name they choose to give to it. The point is that constitutionally, leadership of political parties must be made through a democratic process. That is what the Constitution says. That is what the Constitution says. But we have a situation today where the parties are essentially run as, appendages of whoever is in power, whether at the center you have the president pocketing the party. It is even better at the center, at the state level. Political parties are just things that governors do not have any regards for. You have currently governors who are already announcing who their successors should be, whereas political parties are supposed to exist. And you see why I'm making this point is that this explains the crisis in the APC beyond the projected conflict of interest for the next election. Now, INEC is saying 21-day notice was not given of the Congress or the meeting of the party where the leaders of the party were to be elected. Of course, that is in consonance with the Electoral Act. But the interesting thing is that the Supreme Court has ruled that provision of the Electoral Act is not compulsory. I believe INEC knows this, that it is not mandatory, that observatory role of INEC. But beyond that, the challenge I have is that when you now have 7 governors, you see, APC have this culture of impunity. When the Supreme Court, maybe I should call it an arbiter, somehow suggested that you cannot have a situation where a governor or somebody who is already holding another position will be leading a political party, one would have expected that. I think that arose in the Akere Dulu's case. They were from Ondo State. They would have taken hints and done the needful by convening the convention of the party or the neck of the party properly to ensure that the leaders of the parties were properly elected. But you now have 7 governors parading themselves as acting national chairman. And now Buni says, I am still in office. I am only on medical leave. And the one who says, I am the leader of the party is also on medical leave. So maybe, as an aside, a bit of digression. Dr. Abati, don't you find it a bit embarrassing for the APC power that came to power promising change, that after 6 years, the party is now really in crisis, and the man that said the leader of the party is in UK seeking medical attention is not at the State House Clinic, is not at the National Hospital in Abuja. The man that also claims to be the acting chairman of the party is also said to be outside the country on medical leave. So while they are sick, in health-wise, their party is also sick because they have made the country to be sick too. So APC has now brought this cycle of sickness on Nigeria, and that is why it will be very difficult to cure what has become the leadership crisis in the party. But that is on a lighter note. On a more serious note, I do not understand how persons who are governors should have 7 governors as leaders of parties. They ought to relinquish their position. They ought to relinquish their position. They cannot be holding dual of positions. But there has to be a properly convened and properly constituted convention. And this was the point that the Supreme Court had made in the Alimodu Sheriff, the debacle. Because for you to say there is a convention, there has to be evidence of that convention was properly convened. Who will issue the notice for convening the convention? It has to be the national chairman. Or in lieu of the national chairman, and for what I know about most political parties, 2/3 members of the neck of the party can also convene. But that is after they have made a request to the national chairman. So as that today, the convention of APC, who is going to preside, of course, in the absence of the national chairman, the convention can still take place. The Supreme Court also clarified that in the case of Alimodu Sheriff. That is, if supposing the date of the convention.
Hello.
Acting chairman of the party does not show up. So, on the whole, I believe that the best way to address this is for the conflicting interests within the APC to be harmonized. But maybe it is even in the interest of the country for the crisis to go on, Dr. Basi. And this is my personal feeling now. I do not think that APC being in crisis is affecting the country negatively. The country may actually benefit from it, because what does it translate to? If the party that has brought Nigeria to its knees. The country is in crisis. If the party is now in crisis, why should that be a problem to me? I am not bothered about the crisis that has plagued the party, because the party has also brought the country to its knees. The same way they have failed to manage the. So let them stop this caricature that they are making of the entire, process. If Buni is saying that he's still the chairman of the party, when is his tenure going to elapse? And for what period was he elected or appointed to be acting chairman? You cannot have an acting chairman of a party except that person is elected through a process.
Okay.
There has to be.
Hello.
The process of election of the APC constitution also says.
Okay. Well, anyway, just before we go, I have a comment here from Foluke Ademokun. She says, I do not think a constitutional amendment that demonstrated significant bias against more than half of the Nigerian population should be adjudged successful. Let us address this national crisis, please. We cannot afford to make this an appendage to the discussion. Well, I don't know whether we're guilty as charged, but I guess that, it's just important to know that the House of Representatives says that it will take a second look at 3 of the gender bills when it goes through the second round of the constitutional amendment process. I don't know whether you want to comment quickly on those 3 issues that the House of Reps, speaking through the Speaker of the House of Reps, says that will be addressed again. And this will have to do with indigenship, citizenship, and affirmative action, what you call proportional representation.
Of course, I have made the point that there is need for a constitutional amendment to enshrine and entrench the issue of proportional representation for women, so that this can be handled in a systematic way. But let us not deceive ourselves, Dr. Abati. Even if you have this provision enshrined in the Constitution, the moment you leave room for discretion, the moment the parameters is not set, the purpose is defeated, and that is the mistake or the lesson that we should learn from the not too young to run. Much of this is political and legal, because if the problem is on the success of the Constitution, then it is not only women that will complain. Almost all part of the country is disadvantaged. The youths have been sidelined, the disabled have been sidelined, and women have also been sidelined. So you have this cult of men, if I can use that expression, cult of old men in power, who are threatened that should we allow a constitutional amendment to reserve a certain percentage of positions to women, they are going to be kicked out of the process. This is the truth of the matter, that they will not be placed in the system, which is why they are terrified. Don't forget that even when the National Assembly allows this bill to scale through, they still have to go through houses of assembly, and to talk, at least 24 houses of assembly must vote in support of these bills, which is where the real fight is going to be. And I would like to see how the conservative part of the country is going to vote. Those who have certain religious perception that this is against their religious orientation, I would like to see how they vote from certain part of the country is going, which is where much of the pressure has to go. That is, if the National Assembly had the decency to revisit the issue, and of course to allow the bill to scale through, which is the minimum that they should have done. You can't just shoot down that bill at that stage. Let it be passed. Let it go to the various houses of assemblies. Let the women who occupy a large chunk of the voting population begin to exert pressure at the states. Let us see how many governors, how many houses of assemblies will be progressive minded to allow this to scale through. But there is also the other aspect. At the political level, how many women today occupy offices in political parties? How many? So women must also understand that they have the power, they have the voting strength to bring about the change that they desire. But when the women themselves, have not done enough with this political dimension to entrench themselves, to integrate themselves in the political system, then National Assembly can pass laws, but implementation becomes the different thing. So I agree that those bills should be represented and should be passed. But beyond this cosmetic constitutional amendment, Dr. Abati, which is maybe the last point, this cosmetic, this pretentious amendment that we are having, we need something more holistic. We need something drastic. We need an entirely new constitution. Because what they are doing now, they are trying to fix a foundation that is broken. And I don't know how they are going to do that. That trying to fix a house that is broken without going through itself has a problem. And that problem cannot just be addressed through cosmetic amendments. There has to be something that should happen drastically so that all these issues that we have addressed, for example, even the question of immunity for governors, should be addressed. The question of true federalism, fiscal federalism, should be addressed. Independence of, key institutions of states, like the judiciary, have not been sufficiently addressed. You cannot have these kind of amendments through a system that is benefiting from the current provisions. Those who are in that system, and that is why you see this resistance, and you continue to see people resisting with kind of suggestion, like the way they throw out the bill to ensure that public officers do not send their kids abroad. There is no way that was going to pass, because almost all of them, their kids are abroad schooling. They will not vote against their interests. So for us to stop this systemic, periodic agitation for amendments, let us have a unified process, something more holistic, which is actually what the APC promised. Because they said that the Jonathan's National Conference was not good, was fraudulent, was manipulated. They now promise their own restructuring. They set up a restructuring committee. They have not implemented the National Conference of President Jonathan. They have not also implemented the so-called restructuring report of the APC led by Governor Rufai, which is why I was saying that if the APC is in crisis, it is to the benefit of Nigerians, because they have totally reneged on their promises to the country. They have reneged. They have not kept faith with the promise that they made. They have not. So let us do.
Hello, Enebe, are you
something
still
more holistic. Venture. Every leadership of the National Assembly, billions is devoted. It's voted every 4 years for constitutional amendment. No country can progress by amending the constitution every 4 years. It makes nonsense of what is supposed to be a constitution. Constitution is supposed to be the organic law. It's not supposed to be a document that should be told with every 4 years. No, that is not how a country should.
Okay, Enebe.
Develop. That is not how to address. Until the fundamental issues are addressed, we will continue to see this kind of issue.
Okay, just before we go, I'd like to take this comment from Emmanuel Igbine, which is sent in via Zoom. He says, I totally disagree with the respected Honorable Justice Akwa's judgment on Governor Umahi. What is more, PDP lacks the moral authority to even initiate the suit, when the same PDP in year 2020 admitted and supported Edo State Governor Obaseki to defect from APC to PDP without asking him to leave the mandate behind with APC, on whose platform he was elected. So this is a moral angle to it. Briefly, Inebe, so that we can wrap this up today.
Oh yes, which is entirely true. And that is why I told some people the other day, I said, look, when you read that the governor has left PDP for APC, don't be emotional about it. Because in the table where decisions are taken, these people do not really care about the name of the party. It is about their interest. Because the same PDP that went to court to challenge defection of their governor to APC, they are also beneficiaries of this immoral defection. That is the truth of the matter, which is why the judiciary must also look at the matter carefully. Because if this judgment stands, what happens if the next person who is now coming to replace Umahi also defects? Will we now have another? Let there be a constitutional provision so that at the time of contesting, it will be clear to the governors, to be clear to the president and whoever is running, that if you defect, you are going to lose your position. Until there is a clear-cut constitutional provision, as the Supreme Court said in Atiku Abubakar's case, then this cycle of questionable defections will continue. And the reason these defections are taking place is because these parties are not principled, they are not ideologically driven. You cannot show me a distinction between them. Today, somebody is in APC, the next moment is in PDP. It is so embarrassing. Look at the primary that just took place in Osun State, Dr. Abati. You have somebody contesting for a primary, leaving one party to the other to contest. He lost the primary, he now went to a third party. So you see these politicians, they are neither, they don't have allegiance to the people, they don't have allegiance to morality, they don't have allegiance to the law, they only have allegiance to their selfish interests. And that is why some of us have chosen, to just stay on the sideline and allow them to die in their war. Because I would not die in their war, which is what Dele Farotimi has advised all of us. We must not die in their war, whether they defect to APC or others. I, as the lawyer, can only speak to the law, but regarding whether I am bothered, I am not bothered that Umahi is in APC. Because what has changed? PDP to APC, what has changed? What is he doing differently that he didn't do when he was in PDP? And the PDP governors too, what are they doing differently from their counterparts in the APC? It is all the same cycle of impunity and lawlessness. So that tells you that in the story of the Nigerian people, the defection of these people does not matter. And that is the conversation that we should be having. Why are we bothered? Why are we emotional when these people defect? It's not as if they are defecting because they don't agree with policies. Dr. What is their position on those bills? Did they stage a walkout? Did they vote? Did they take a position that they support those bills? Where do they disagree with the APC on the loans that the president is taking? What is their position on healthcare? Are their governors not going abroad for medical treatment? They are not doing anything differently. So the members of the ruling class are together when they pretend to fight Nigeria state sides with them, which is not supposed to be the case, because in reality, these people are one and the same. For me, defection is not a problem to me, which is why the Supreme Court cautioned in the case of Udedo and Nande on the need for judges to stay away from politics and politicians, because they are not guided by principles, unlike law. They are not guided by policy. They are not of it. Yes.
Well, okay. Okay, we lost connection there again, right? It seems. Hello?
That is a reality. PDP from the fact. Yes, please.
Hello, anybody, if you could just hold on. It seems like we have a caller on the line. Let's just take that caller before we wrap it up. Yep. Good afternoon.
I want to say that. Hello, I want to see that part of community. And it was because of other people who said they don't qualify to go for second term. And because of that, you can imagine all the oppression and all that they get to that one. And he had a 50%. Welcome you. But that of the mind, nothing was doing back in 5 years. He was a PDP. Second, another second tenure, he was just only how many years remaining. You know that because of what he wants to eat at the sector. All that is different. So let us not take it as the case. Thank you.
Okay, thank you very much. I think at this point, I should also thank you very much, Inibi Efyang, if you can hear me, for taking time out to discuss these issues, Ebonyi State matter, the APC leadership crisis, constitutional amendment, the protest by Nigerian women over the rejection of 5 major gender bills in the constitutional amendment process. I also like to thank all our callers and those who reach out to us on Zoom and Facebook. Remember, the conversation does not end here. You can still reach out to me on my social media account at Abati1990 on Instagram and also at City1051 on all social media platforms. For those of you who tuned in late, well, there's no need to worry. You can visit YouTube page City1051 to watch the entire show. And don't forget to hit the subscribe button and leave comments. And don't forget to tune in next week also at 12 noon for another exciting edition of City Talks. My name is Reuben Abati. The show was produced by Adedoja Allen, Charles Flames, Abiodun Odunton, Ayodamola Oludara, and Oluwaseun Adetiton. Thank you very much for joining us again today. Have a great weekend. We'll be with you again next Saturday. Bye for now.
City Talks with Reuben Abati.